and welcome to this video lecture on drafting first appeals and second appeals, which is part of Unit 6 of our advanced program on civil drafting for practicing advocates. Hi, I'm Richa Kaur. In this video lecture, we learn about how to draft pleadings for first appeals.
Hi, I'm Aditya Narayan. Remember that a first appeal is granted very high value in civil jurisprudence. This is because human error is pervasive and cannot be excluded from the judicial process as well. Consequently, it is necessary that every judgment of a court at the first instance be subjected to a full appeal. It is in this backdrop that it is a foundational principle that the entire matter be at large before the first appellate court. The first appellate court considers all issues of law and of fact, de novo, that is, afresh. A first appeal is initiated by a party that is aggrieved by the judgment of the trial court. Such a party files a memorandum of appeal which contains the following elements: the cause title, the heading, the body of the appeal, the prayer column, and the verification. Let's learn about these elements. The cause title is similar to the cause title of a plaint with a few significant differences. Here, a cause title comprises of the name of the court, the number and year of the case, and the names and addresses of all parties. Please note that the cause title will show, alongside the names of the parties, the ranks of the parties in the appellate court as well as the trial court. Next, let's learn about the heading of the Memorandum of Appeal. The heading states the provision of law under which the appeal is filed. Moving on, let's look at the body of the appeal. This can be divided into three portions: a statement of the background facts, a statement of the grounds urged in support of the appeal, and formal pleadings on procedural aspects. Let's first learn about background facts. While it is not necessary to set out the background facts in the Memorandum of Appeal, it is considered good practice to set out the facts for the court. While setting out the relevant facts, be sure not to assert any new facts that have not been stated before the court below. Also, endeavor to remain neutral in your statement of facts. State facts that are against you as well, but ensure that the statement is not construed as an admission against you. Additionally, include a summary of the proceedings before the court below. In this summary, be sure to identify the contentions of each party, the issues framed by the court, and the number and identity of the witnesses that deposed on behalf of each party. The issues framed by the court and the number and identity of witnesses that deposed on behalf of each party. Also discuss the findings of the court on each issue and summarize the final judgment of the court. We have learned how to draft the statement of facts in the body of an appeal. Let us now study how to draft the grounds of an appeal. The grounds are formulaic statements of the reasons that you contend render the judgment of the trial court erroneous. Remember that your statement of the grounds should adhere to Order 41 Rule 1-2 of the CPC, which provides that the grounds of objection to the decree appealed from shall be without any argument or narrative. It's important to be exhaustive in stating your grounds of appeal, since Order 41 Rule 2 prohibits a party from urging grounds that have not been stated in the following terms. The appellant shall not, except by leave of the court, urge or be heard in support of any ground of objection not set forth in the Memorandum of Appeal. But the appellate court, in deciding the appeal, shall not be confined to the grounds of objection set forth in the Memorandum of Appeal or taken by leave of the court under this rule. The logic for this rule is clear. The proviso to Order 41 Rule 2 states that the court shall not rest its decision on any other ground unless the party who may be affected thereby has had a sufficient opportunity of contesting the case on that ground. Not having stated a ground in your memorandum may, consequently, result in the court refusing to hear that contention or pass judgment on that basis. Finally, let us turn our attention to the last part of the body of the appeal, that is, the procedural pleadings. The position of the procedural pleadings in the appeal are set out in the reading materials of this unit. Remember that these pleadings include pleadings regarding address for notices, jurisdiction, limitation, and court fees. With this, we complete our study of the body of the appeal. Let us now learn about the prayer column. The prayer column is similar to the prayer column in the plaint, except that here you will request the court to set aside the judgment of the court below and decree the suit or dismiss the suit as the case may be. An affidavit is not required in a memorandum of appeal because no new facts are pleaded. However, it should carry a verification which is of similar form as that contained in the plaint document. The appeal may be signed by the party or his pleader and is accompanied by a valuation slip which is of similar form to that filed with the plaint document. The court may, where it wishes to admit your appeal and consider it in detail, require you to file a paper book. A paper book is a compilation of all documents relating to the proceedings before the trial court. The manner of its compilation will be set out in the relevant civil rules of practice. Remember, you can challenge the findings of the trial court as a respondent in cross appeal by filing cross objections which bear a similar form to a memorandum of appeal. This concludes this session on first appeals. In this session, we have learnt about the jurisprudential value of a first appeal, the form of a memorandum of first appeal, and the form of cross objections. In the next unit, we will review the drafting of second appeals and interlocutory applications in appellate proceedings. Thanks for watching. Please do attempt the practice exercises before moving to the next unit.